3, 2, 1. All right. All right, everybody. Hello and welcome. Hello and welcome. Thank you for being here and welcome to another episode of the Empowered Immigrant Live. My name's Otis Landerholm, and I'm happy to be here with you today. It is the 1st of April. It's April Fool's Day. Can you believe it? The 1st of April of 2025. Today our topic is the new NTA memo, Trump's new NTA memo. I want to discuss that with each of you here today. And thank you so much for being here. Really appreciate your tuning in to another episode today of the Empowered Immigrant Live. Remember that the Empowered Immigrant Live is here to train, teach, inspire, and empower immigrants to make the most out of immigration laws and to make the most out of their lives. All right? Today, our theme is Trump's new NTA memo. All right? And my question for everybody always is, hey, do you want to get a green card? Do you want to apply for asylum? Do you want to figure out what's the best strategy? What's the best way? What's the best approach to maximize your chances of approval so that you can fix your immigration status and get past this immigration issue for once and for all? All right? Because if you want that, go for it. At least get good advice about it. All right? And I'd love to help you with it. My firm is on a mission to win 10,000 immigration cases in the next 10 years, and we would love for your case to be one of them. All right? So thanks everybody for being here, and welcome. And I'm grateful to each of you for being here. Again, my name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. We're a law firm based in Oakland, California, and we fight cases for immigrants throughout the United States. All right? So thanks for tuning in. Really appreciate each of you. So it's April, folks. All right, April of 2025. This year is going by. It's going by quick. All right. There's a lot of changes that are happening. Trump has been back in office, really 2 months and 1 week. All right, 2 months and 1 week, and a lot has changed in those 9 weeks that he's been back in the White House, and. You know, the Laken Riley Act was signed into law. ICE is getting going with its mass deportation efforts, right? The Senate and the House have approved Trump's budget to enable him to do that. There's been a registration requirement announced. DHS fired the acting director of ICE. They hired new leadership in ICE. They've fired many immigration judges, not to mention all our friends at the Department of Education and many of the other federal employees. There's health employees that are losing their jobs today. And you know, it is interesting, right? Like, let's think about society in terms of let's spend less dollars on education and more dollars on deportation. Yeah, like that's backwards, folks. It's backwards. It's my opinion about it, but it's messed up. All right? And there's proposals for a new travel ban, and there's lots of other things that are happening. All right, one of which is the NTA memo that we'll discuss. Some good news today: the registration requirement, which is set to take effect on April 11th, has been challenged in the courts. All right, and so that's. You know, we'll see what happens there. We'll see if any of those challenges succeed. But, and we're not surprised that it's been challenged in the courts. And so we'll follow what happens there. And if you're curious what happens with the registration requirement and the lawsuits that are challenging it, you know, please subscribe to our channel or please give us some love in your platform, whether you're on YouTube or Facebook, LinkedIn, Instagram, TikTok. Like, follow us. And we can continue to give additional updates as soon as they're out, right? As soon as we know what happens there. Okay? So So what's this new NTA memo? Well, first of all, what's an NTA? All right. An NTA is a notice to appear in immigration court. It's basically the document that charges a person with being either inadmissible or deportable, and it starts the process of deportation proceedings. Okay, that's what an NTA is. And so what's this new memo? Well, it was released on February 28th, so it's been in effect now a month and a day, really. A month and 3 days, I guess. And it's not a huge surprise, right? In fact, it's almost identical to the NTA memo that was issued under the first Trump administration back in 2018. And basically what it says is when you file a case before USCIS, right? And if you withdraw that case, or if you have that case denied, and if you don't have any other status, right? Or if there's an argument that you are deportable, whether for criminal record maybe, or fraud maybe, or for any reason, if USCIS denies your case, you'll receive an NTA. All right? Even for VAWA cases, even for U visa cases, even for cases that in the past USCIS might not have done this, right? Or that under the Biden administration or under other administrations, they would have, in their discretion, not NTA'd folks if their application gets denied. Under the Trump administration, they will do that per this memo. Okay? So does that mean that a person is automatically deported? No, it doesn't. What it means is there's going to be more people in immigration court proceedings. There's going to be more people who are facing deportation in court. And so practically speaking, what does that mean for everyone? It means that the stakes get higher. Does that make sense? It means that the risk is higher, which means that when you file anything to USCIS, you want to do a good job. You want to do a professional job. You want to do everything that you can to make sure that the quality is there so that your case gets approved. Your case can still get approved, but if it gets denied, it's much more likely that you'll be sent to immigration court. Okay? The effect of this will be to put more people into immigration court. The other effect of this is that immigration court processes are just going to take longer and longer. Right? We've got cases already that are set out to 2029, all right, which is crazy. And that's what's going to start happening, that immigration court is going to get longer and longer. And as I mentioned, the stakes are going up. So it's not the time to work with a notario, all right? And it's not the time to hire some amateur lawyer that doesn't know what they're doing, or to hire some family law attorney that dabbles in immigration law but doesn't really know what they're doing, right? That's a bad strategy. Instead, you want to hire a professional. You want to hire a law firm that's really going to have your back, all right? And no, that's not a plug to just hire my office. But seriously, you want to hire a professional, okay? And so that's just the reality. And so as I'm talking, if you have questions, please submit your questions, all right? I'll do my best to answer them. And really, you know, this NTA memo, it's not a huge surprise. It's you know, everything that we hear about the Trump administration is like, yeah, it's just kind of, it's maybe just a small piece of the puzzle. It's not an extra big thing that we need to, you know, it's not earth-shattering news, in other words. It's not a surprise. But it is something that matters to individual cases, and you'll want to talk it through with your lawyer so that you're assessed in terms of what are the risks, what are the benefits, so you can make fully informed decisions. As everybody knows, there's always going to be risks to filing an immigration case, but the opposite's also true, right? There's risks of not filing. All right? There's risks of not filing. And so it's like when you have a legal argument to apply for a green card or an asylum case or something, like you really want to talk it through and evaluate the pros and cons, evaluate the risks and the benefits. With a lawyer who knows what they're doing, they can give you good advice about it. Okay? That's really it. That's really it. So, so thanks for being here. Let me know what questions you have, and I appreciate everybody for tuning in today. Again, my name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C., where we fight for your American dream. And I'm about to sneeze. I'm sorry for that. I'll blow my nose. So, all right. So, Ana Granados, I see your question here. Thank you for asking it, and thank you for being here. All right. You say, recibí la cita por correo de la entrevista del 40, or de 485i. No, you're saying the I-485. Una hora antes será error de el oficial. All right. So, that's a good question. That's a weird situation. You're saying you got a notice for an appointment 1 hour before your interview. That's weird. That sounds like scam or something like that. Talk that through with your lawyer. Unless it's like an appointment with your lawyer to meet up before your interview. But you should be practicing and you should be prepared for the interview well in advance. Typically like a week before your interview, you want to prepare for your 485 adjustment of status interview. Okay? So, all right, my next question here comes from Nope. It says, LED panels are way more efficient than those old fluorescent lights. You're talking about above me. Thank you. Tell my building manager, right? So, fun fact, we are in a building near the Embarcadero of Oakland, and I've got boats right outside my window here. It's very beautiful. But our lease here actually expires on December 31st of this year. And so right now we're thinking, okay, do we want to reassign our lease here, or do we want to find a different space? Maybe we could use LED, find a space that has LED panels, to your point there. So anyway, that's something that we're dealing with. All right, Potato. I see your name there. That's a great name. You say, let's see, I'm self-employed. Why do I need a sponsor on my marriage-based adjustment of status? Well, thank you for asking that. You might not. You might not. It depends on your income, right? You've got to look at your total annual income. And so we've done this for, I've got lots of folks that are self-employed that can sponsor themselves, that can be their own sponsor. Now, if your question is, if you are the immigrant, then, and if you don't have a work permit or if you're not, if you're not in valid immigration status right at the moment, then you might not be able to use your own income, right? If you're the immigrant. But if you're like the U.S. citizen sponsor, then you can use your own business's income, and whatever your business pays you personally, you can certainly use that for your sponsor. All right? Joanna Bustos, you say, what is the process for self-deportation, and can we apply after self-deporting? Don't do that. Okay? Bad idea. Really bad strategy. There's a lot of buzz out there by the government that says, oh yeah, everybody should deport themselves. Please don't do that. Talk it through with a lawyer very carefully before ever jumping to that conclusion. It's a bad strategy. All right? What happens is if a person deports themselves, they automatically, on exit, by law, they trigger a 10-year bar. Okay? And so it's like, don't do it. It's a bad strategy unless there's a way that you can waive that 10-year bar before you leave, right? Which is possible in some cases. But if, or, you know, in some instances, there's a way to fix the case here in the U.S. And whenever there's a way to fix it in the U.S., that's advantageous. It's so much better. Okay? So, Joanna, I hope that answered your question, and thank you for asking it. Vieja mitotera. All right. Thank you for being here. You say, can I apply for a U visa after I applied for a VAWA? Yes, 100% you can. I've done that. You know, one of my first, one of my early cases, right, was a client who had suffered domestic violence. And she had suffered domestic violence from a U.S. citizen abuser. And she won VAWA. And her previous lawyer was like, yay, you qualify for VAWA. Let's get you VAWA. But her previous lawyer didn't explain and didn't really go through her case to know that she was never going to be eligible to adjust status through VAWA. Why? Because she had what's called a permanent bar. She had left and re-entered the U.S., and it didn't fit one of the exceptions. Like sometimes the permanent bar can be waived through a VAWA case, but hers couldn't, right? And so what do? She won VAWA. She's got VAWA. Hey, let's file a U visa, right? So the direct answer to your question is yes, it's possible. Yes, you can win that case. You know, in my office, we won that person's U visa first, then adjustment of status, and then now she's a U.S. citizen because we helped her through the U visa, which can waive a lot more things. She could get green cards and citizenship through the U visa process where she was stuck and was, you know, with her previous lawyer, she would have been stuck renewing a work permit through VAWA for the rest of her life. Right? And instead, now she's a U.S. citizen. And so, yes, the answer to your question is yes, you can apply for a U visa even after you applied for VAWA, and sometimes that's the right thing to do. Right? So there's that. What other questions are out there? And for everybody that's tuning in right now, welcome, and thank you so much for being here. I was talking about the NTA memo, right, which the NTA memo basically says that if a case gets denied by USCIS, then USCIS will, if a person doesn't have other immigration status, USCIS will issue an NTA, a notice to appear, and start a person in immigration court proceedings. All right? So that's what we were talking about, and thanks to everybody tuning in right now. My name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C., where we fight for your American dream. And so, so let's see. I see a question here from user 849. Thank you. You said, hello. A while back, I asked the CWC. What do you mean by that? Would that stop me from becoming a citizen? I was approved. I don't know what you're talking about. Continental Western Corporation. What is CWC? CWC Military Watches. No. What does CWC mean? It means Chemical Weapons Convention. What? There's many acronyms of CWC. I'm not sure what you're referring to. All right. So let me know. And would it stop you from having your citizenship because you were approved for that. I don't know. Maybe probably. I don't know. I don't know. You'll need to tell me what CWC means. All right. As long as it doesn't involve your moral character in some way, or as long as you weren't lying saying you were a U.S. citizen to get that, as long as there wasn't any fraud like that, then it shouldn't cause a problem for your citizenship case. All right, Juju99, you say, my mom has an expedited deportation from more than 10 years ago. Okay. So the question is for you, and thank you so much for asking this question, all right? The question for you is, after your mom was expeditedly removed, did she then enter the U.S.? Right? Did she then re-enter after the deportation? Because re-entry after a deportation causes a permanent bar. Okay? But if she did not re-enter the U.S., and if now that's happened 10 years ago, then great, you can file a petition for her, and she's no longer inadmissible by it. An expedited removal causes a 5-year deportation bar. Okay? And so then if that much time has passed, then you could petition for her and she could still get a green card. So Juju, in other words, the question is, did she re-enter unlawfully after the deportation, or is she still outside the country? Because if she re-entered the country, then you cannot process a green card for her. She has a permanent bar. She's not eligible through family. But you're saying she's still in Mexico. So if she's still in Mexico, then there should be a way. There should be a way, as long as there's not other inadmissibility issues. All right. So you have a great case. I'd love to talk with you, and we can at least see whether or not we can help her to get a green card to enter the U.S. Okay. So. All right, those are all the questions that I'm seeing. Let's see what else is here. Concealed weapons charge. Okay, user, I got what you're saying. Concealed weapons charge. A while ago, I got a concealed weapons charge. Would that stop me from becoming a U.S. citizen? I was approved. You mean you were convicted of your concealed weapons charge? Okay. I don't know. So good question. That's a really great question, user 849. Thank you for asking it. My best advice would be to have a consultation with an attorney and to really show all of the records. And if you don't have them all, we can help you request all of the records. It depends on a lot of different factors. All right? When it happened, how many, what was the sentence? What was the actual code section that you were convicted under? Did it happen before you got your green card or after you got your green card? There's a lot that goes into that analysis for us to review in a consultation and then give you good advice about it, right? And maybe you can win citizenship, but you got to get good advice about it first. Good. Let's see. I have a feeling my lawyer filed a VAWA case knowing that I have a permanent bar. Okay, vieja mi totera. I got that. They should have explained, right? They should have explained that VAWA sometimes can get you a work permit quicker. VAWA sometimes can get you what they call deferred action quicker than a U visa can. But they should have applied for a U visa also, because the U visa comes with a waiver that can waive the permanent bar. Okay. Silver Fox, I see your question here. So an NTA, will a motion or an appeal help you with an NTA notice? It can. Yeah, it can. So, but if the appeal is ultimately denied, they could still issue a notice to appear. Of course, when you have a notice to appear, great, fight that case in court. And if you lose in court, then you can appeal again. Right? You appeal to the Board of Immigration Appeals. And so motions and appeals can help you at various steps of the process, both in front of USCIS and in court. All right. Nacho El Gato, I see your question here. How long does the citizenship process take? I'm a permanent resident married with a U.S. citizen. So different field offices process citizenship differently. 5 to 8 months is what we're seeing right now. Okay, 5 to 8 months, and I expect that to slow down. Basically with what's happening under Trump, we expect all processing times to slow down as time goes on. Okay. There's a question here from Pablo. You say, is it still safe to travel with advanced parole? That's a really good question. The best advice is to get specific advice about your situation. It's risky to travel with advanced parole if you're from any of the countries that are facing the travel ban, whether the red list, the orange list, or the yellow list. So look at that first. It's also risky to travel with advanced parole back to a country that you fled from and that you filed asylum from. But aside from those two issues, you should be okay traveling with advanced parole. You just got to be aware of what's happening at the border right now. All right? There are border searches happening. I'll do a whole other episode on what's happening at the border in terms of, delete crazy social media stuff off of the apps of your phone. If there's anything that could potentially be interpreted as anything to do with drugs, gangs, anti-American foreign policy, any of that stuff, it's wisest when you're traveling to delete that stuff off your phone. Okay? Silver Fox, I see you here. I do not have an NTA yet. It was in the memo of the denial letter. I did the motion this week. Okay, good. So you're saying you did an I-290B motion to reopen or reconsider your USCIS case, right? And you don't have an NTA yet, and you're going to see what happens with that motion first. If the motion gets denied, then you'll be NTA'd. And if the motion gets approved, then your case will be reopened and you'll be adjudicated in front of USCIS. Yeah. So good. Sounds like you're doing it correctly, right? All right. Let's see. So Da Villain, thank you for being here. How long is a residence card for my wife? I am a resident. You mean how long does it take to get a green card for your wife? That depends on a lot. So, if you're a resident, first step is you file the petition for a non-citizen spouse, and then that petition takes a couple years, right? And then after that petition's done, then you can, then your wife can apply for adjustment of status if she's still in current immigration status herself. And if she's not, then you got to become a citizen first, okay? Unless she's protected by 245I. It's a process, right? My best advice, Villain, is to speak with a lawyer about your specific situation. If you can become a citizen first, that helps speed up the process for your wife. If she's already applied for her green card, then maybe that doesn't, it's not as big of a deal then. Should be just a couple, really it should be 24 months or less, if she's already applied to get her green card. All right, user 849, you were already approved for your citizenship. Okay, good. If you were already approved for citizenship, then you're already a U.S. citizen. No, a criminal record will not affect you. Okay? A criminal record will not affect you. The only way that they can take away citizenship is if there was a lie, misrepresentation, or fraud in the getting of your citizenship. All right? Or if you relinquish citizenship and repatriate, which is a different process. Right? But yeah, once you're a U.S. citizen, once you're a U.S. citizen and that citizenship was lawful, then now you're good. All right, you're a new criminal record or whatever. They can't use that to reopen your immigration case and take it away from you. Okay? They can only do that if there was like fraud or misrepresentation in your getting citizenship. Okay, so Susi da Silva, do you think there will be any immigration passing? You mean like any immigration reform passing, right? Like the Dream and Promise Act, right? Yeah, or the Dignity Act. Yeah, you know, all of these were, great question, great question. Certainly, certainly it's possible, right? Certainly it's possible, and we will find out. I don't have any strong opinion at this stage, right? But yeah, I will be monitoring that, and as there is more, you know, as any of them pass one side of Congress and actually move forward and start looking more serious, I'll do a lot more videos about them so that we can be monitoring and be on the same page about what the chances are. Okay, so good. So stay tuned for that, and thank you for asking that. All right, Nestor Gonzalez, you say, can I travel to Puerto Rico with DACA while I'm adjusting status? Yes, you can. Yes, you can. You shouldn't have an issue coming back from Puerto Rico. However, there is like it's not full customs coming back from Puerto Rico. I'm trying to think, you know, would it be wisest to have an advanced parole process approved for you before your trip? Yeah, if you have advanced parole, I'd feel a lot better about it. It shouldn't be required. But what my best advice, just standing here right now, would be to have an actual consultation so that we can give you good advice about what documents you should have in order before you travel to Puerto Rico. Yep. All right. Any update on the Calderon Jimenez versus Mallorca settlement? Thank you for that. Thank you for that. I did look this up, and I don't have it right in front of me as I said I would, but Lupita, thank you for asking. All right, this was a notice of approved settlement in the Calderon case is impacting New England area non-citizens who have final orders of removal and are married to U.S. citizens. Summary by class counsel at the ACLU of Massachusetts. All right. On January 16, 2025, Federal District Court approved a proposed settlement in Calderon Jimenez versus Mallorcas. This case, sorry, let me move this front and center a little bit more here. The case was filed in 2018 on behalf of a class of certain U.S. citizens and their non-citizen spouses who have final orders of removal and live in the New England area. All right? So the 2-year settlement agreement has 2 key terms. First, it provides a process by which most non-citizen class members should be able to reopen and dismiss their removal proceedings. And second, during the 2-year period of the settlement, ICE may not take enforcement actions against class members except when ICE determines that an individual poses a threat to public safety. Okay? And so there's a great publication there's a great publication of the kind of summary of this class member. It only applies to people who live in New England, which includes Massachusetts, Rhode Island, Connecticut, Vermont, New Hampshire, or Maine. All right? Or if your non-citizen spouse is detained in any of those states. Okay? And then there's other qualifications that you have to match under. So Lupita, does that answer your question? I hope that answers it. That's what I got about the Calderon Jimenez versus Mallorcas settlement. All right, so it says, do you really think now is a good time for a spouse to file an I-130 for his spouse who will require an I-601A for unlawful presence? You know, it's a fair question. Yes. My honest answer is yes. Why do I say that? Because it's better to have something pending than nothing, right? My answer is not, like, you could ask 10 immigration attorneys and we'll all have different opinions about this, all right? In my opinion, if your spouse has a good case for an unlawful presence waiver, has a good case for an I-130 petition, right? Then yes, do the case. For me, it's like there's no time like the present, right? You could always say, oh, things might get better when a new president comes into power. Yeah, they might, all right? But man, like, take advantage of the opportunity that exists in front of you now. The time to take action is now. And that's the way I see it. Okay? And there's some people where that case isn't that good of a case. It's not a strong case. It's not, you'll probably be denied. When that's the situation, okay, maybe not. And some people, it's like you really need to talk it through with a lawyer before coming to that conclusion and not just relying on, advice from a lawyer on the internet like me, all right? Like, actually come in and let's talk through the case is really the right way to do it. Okay. We're doing great, folks. We're doing great. Thank you all so much for being here. I love that there's so many questions coming in. Really appreciate it. If you're just tuning in right now, my name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C., where we fight for your American dream. And thanks for coming in. I've got a few more minutes for a few more questions, and then I want to wrap up and get into the Spanish version of our episode today. All right? So what I'll do is I'll take 5 more questions, and I'll do them more quickly. All right? And so Wayne West, I see your question. I had 2 drug charges but no conviction. Is it okay to travel or file my citizenship after 2 drug arrests with no conviction? Okay, this is a great question, and thank you so much. You're not alone, all right, in your situation. So thank you so much for being here. Thank you for asking it, all right? My best advice is we should really look at what the records say before coming to that conclusion, because when you apply for citizenship, they will ask you for all the records, all right? And right now, per the NTA memo, if a person is quote-unquote deportable, they'll send you to immigration court. Now, if you're quote-unquote deportable and they send you to immigration court but you have a green card, you might be eligible to apply for what's called cancellation of removal for permanent residence, E-42A cancellation. And so it's like you might have a great case, and you might be like, you know what, let's do this, right? But we should really look at the records carefully first, right? So that you can do a full assessment about what's the risk, what's the issue, if those arrests, if there were arrests and charges but no conviction, they should not cause quote-unquote deportability at all right? But still, they'll ask for all those records, so we'll want to be ready to respond, and we'll want to review them carefully before deciding whether or not to apply. All right, so thank you. Thank you for asking that. Feel free to call our office. We're here to help. We'd love to help, and we could get started with a consultation. Okay? Let's see. User 14789, you say, what's the latest update regarding the travel ban on those countries? Okay, there is no news. All right? There is no final implementation of the travel ban yet as of today's date. All right? Well, I should say that. I didn't double check in the last 30 minutes, but... Yep, USA Today, 18 hours ago. Trump travel ban indefinitely delayed as U.S. continues to revoke visas. Yeah, so it's continuing to work on their travel ban, all right? It has not been fully implemented yet. It's been out there, all right? And so we don't know. We don't know exactly when it'll be formalized and formally in place. And so that's the news. That's it, right? Ju1, I see your question here. Can someone with asylum with withholding get permanent residency? Well, those are two very different things, all right? Asylum is one thing. When you apply for asylum on an I-589, you're applying for asylum, quote unquote, and you're also applying for withholding of removal. And if you want to, you can also apply for relief under the Convention Against Torture. Only asylum allows a person to win permanent residency in the future and later citizenship. Withholding of removal does not. All right, so if you win withholding, basically what it is the government's ordering your deportation subject to a grant of withholding of removal because your life or your freedom would be in danger in your country. You know, you're not eligible for asylum for some reason, but you can still get withholding. Like, for example, if you trigger the 1-year bar, right? You're not eligible for asylum, but you, in some instances, can file for withholding. So can someone get with asylum get permanent residency? Yes. Can someone with withholding of removal get permanent residency? No. All right, that's the way it is. All right, and so Ju1, if we could help you with that, and it's not true that it's no 100% of the time. Somebody with withholding of removal that wants to become a permanent resident, you have to file a motion to reopen your case first. All right, and then reopen your case and apply for some other way to get a green card in front of the judge, and then you can get a green card. Okay? That's the way that is. All right. Sid, I see your question. Green card through asylum in 2023, also married to a U.S. citizen since 2021. When can I do the N400, the 3 years rule or the 5-year rule? Thank you. So as long as you got your green card through asylum, great. All right. And so you got your green card, all right? So but you're married and living in marital union with a U.S. citizen. So what the law says is you can apply for citizenship after 3 years of living as a green card holder in marital union with a United States citizen. So you won your green card in 2023. You should be eligible to apply for citizenship in 2026, as long as you can show that you've been living those 3 years in marital union with a United States citizen. That's the answer. Okay? All right, KKKKK, good to see you here. If I didn't get a work permit yet under the U visa application, does that mean that the application has been denied? Not necessarily. All right, work permits take a while under the U visa. So no, not necessarily. Catherine, U visa or USCIS received my VAWA on January 21st. I got my prima facie on March 10th. I got my fingerprints taken March 24th. Is that a good sign to be this fast? That's cool. That's great. Yeah, it's a good sign. Yeah, it's a good sign. So that's it means you've got your prima facie done, and now it's going to be pending for a long time before they issue the final approval. Okay? And now the question becomes, did you also apply for your green card with your VAWA case, or do you have to wait, you know, for either the priority date to become current or for some other thing to become ready for you to apply for your green card? Okay. Mario, does VAWA forgive the permanent bar? Only in rare situations. Only if the permanent bar, the triggering of it, the leaving and reentry, was somehow connected to the abuse you were suffering. Okay? Most times, I mean, so that's the exception, right? If you just have a regular permanent bar, then no, VAWA cannot waive it. You can still win VAWA as a work permit and deferred action, but you cannot waive it for applying for a green card. Okay? So that's a little bit of a nuanced answer to your question there, Mario, but thank you for asking it. All right, Kristen, you say, how long after you submit VAWA are work permits approved? That's a good question. That's a good question. It's not an easy question to answer. All right, just talking to Catherine, it looks like she got her prima facie in 3 months, and that prima facie order allows her to apply for a work permit. And so that's fast. All right, I've had cases where it takes 1.5 years or so to get the work permit through VAWA. All right, Mo Abdos. I got asylum approval notice. Can I apply for a green card now? Yes, you can, but you can't get your green card now. You can apply now, but you can't get it yet. You have to have 1 year with your green card before you have to have 1 year with asylum before your green card can be approved. Okay. KV Spartan, I see your question here. Is it safe to travel with advanced parole, waiting on an I-45 with no criminal records, married to a USC? Yes, it's safe to travel. All right? Delete bad stuff, anything even controversial from your phone before re-entering the U.S. because they can search your phone. Don't commit any crimes while you're out of the U.S. Don't go to any of, like if you're from any of the travel ban countries, be cautious about that. Otherwise, have a great trip. Okay? Mo Abdos, oh yeah, I answered that one. Haiti Beautiful, cool. Hello, can a green card holder apply for his wife who entered here with the CBP One app? Yes, a green card holder can. It's a lot easier though. Well, you can apply for the petition. For the person to adjust status, you're going to need to become a U.S. citizen, or that person is going to need to stay in lawful status, all right, which is not going to be easy from the CBP One app. So the question for you is, can you become a citizen soon? You know, you could petition for your spouse, but can you become a citizen while that petition is pending? And then once that petition's approved and you're a citizen, you'll be able to adjust your spouse without issue, all right? Even if they are no longer in valid status, a citizen can adjust a non-citizen spouse even if the non-citizen spouse is outside of regular immigration status. All right, does that make sense? That's the way it is, folks. That's the way it is. All right, Jordan Sanchez, if you have employment authorization, can you get deported if you have a DWI? It depends on, it depends on lots of different factors. Automatically, no. All right, a DWI is not a deportable offense, but they can certainly use that to deny the underlying case if it's a discretionary type of case, right? If you have DACA, for example, a DWI, driving while under the influence of alcohol, that would, serve as a reason for them to deny, for example, a DACA case. So it depends on the underlying case that you have, Mr. Sanchez. All right. Good. So that's all that I'm going to answer today. There's a lot of other questions that are here. This has been great. Wow, we've been going strong for a long time. Here it's 11 o'clock. And so thank you all so much for tuning in today. I really appreciate each of you. My name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C., where we fight for your American dream. If this content was useful, if this was helpful, please take a moment, go to our channel in YouTube. All right, Landerholm Immigration in YouTube. All right, hit the subscribe button. That would mean the world to us. We're going for 20,000 subscribers to our YouTube channel. So we'd love for you to join us there. And yeah, I really appreciate everybody who is participating with me here live on our show today. And yeah, I hope that you join us on the next episode. And so thank you all so much, and we'll see you next time on our next episode of the Empowered Immigrant Live. Until then, make it a great day. It's April Fool's Day if you're watching this right now, so do something silly for somebody in your life that you care about. Make it a great day, folks. Thanks a lot. Take care. Bye-bye.